Good afternoon. Welcome to Doc Expo 2021. Thanks for the opportunity to join you virtually. I'm sorry I can't be there in person. Times are strange, and this will be a strange presentation because of that, but we'll do our best. Let me introduce myself. My name is Kramer. I'm a mediator. I'm located in Harbor Springs, Michigan, at the northern end of the southern lower peninsula of Michigan. I've been in maritime law since 1982, practicing throughout the Great Lakes area and beyond, and have been mediating for about 20 years. And our presentation today relates to mediation principally, and the title of which is called Cost-Effective Dispute Resolution. And again, we're going to focus on mediation. And mediation as one of the tools in your customer relations and best business practices toolbox, if you will. And so I want to talk about that. And in terms of mediation, we're talking about an alternative dispute resolution, and you may have heard the term ADR at some point or another. So alternative dispute resolution is a way of solving problems that come up, and there are lots of them in the marina context and in the marine industry context altogether, that often end up in litigation. And having practice in both fields of litigation and in mediation, I can say that to have an extra tool in the toolbox is a good idea. And when we talk about ADR, we talk about it as an alternative to litigation. In litigation, you think about courts and trials and lawyers and legal briefs and depositions and the like. And this is an alternative, one alternative to the litigation format. It's kind of a formal exercise, but not nearly as formal as the trial or the litigation process, and I can tell you about that as we go along. Typically, mediation can be described as when parties come together with a neutral third party mediator to discuss the issues and interests of the respective parties to try and come up with a solution. And the goal, again, is to reach a settlement of the dispute. And let's talk about that a little farther. Mediation can be broken down into two parts, essentially. The principal one is, and most commonly run into, would be facilitative mediation, where this neutral third party is involved in trying to settle things without making a decision of any kind with respect to the parties. The decision in all of them are left up entirely to the parties themselves. That's facilitative mediation. There's another type of mediation called evaluative, where you ask the mediator to come up with, well, what do you think the value or the result should be in this case? And in mediation, it's never binding on the parties. It's always left open to determine on their own behalf. But typically, a mediation would be seen as facilitative, that is to say, helping the parties come to their own conclusion without offering any opinion as to what the result ought to be. It differs from another type of alternative dispute resolution, or ADR, known as arbitration. And you've heard of arbitration before, and that is sort of a mini trial, I think you might be able to say, in the sense that one or more than one arbitrator would be designed as the third party neutral, or designated as the third party neutral, and they would come up with an answer as to what the result should be. A little less formal than a trial, but often very, very involved. So mediation is kind of the low end of the involvement or technical end of things, but nonetheless a very handy tool for that toolbox. Oops. When we talk about something of an overview, is what is mediation all about, and why would you want to get into that? I think the first notion that could be taken away for a marina, for a salvage company, for a contractor, that sort of thing, is that about 80%, roughly, of all of the cases that a lawyer gets involved with and gets filed in court won't go to trial. Why is that? Well, the reason is that people are encouraged to settle their case. Of course, the court will often require mediation at some point or another, or some other form of ADR. And as time goes along, the parties get to understand each other's positions, and they will come up with a conclusion and settle the case, but usually only after a great deal of lawyering is involved in the case. Again, depositions and documents passed back and forth and the like. And so when you think of mediation as a tool of settlement, one of the reasons that you might favor that is that you're likely to settle your case anyway. Now, the numbers I've seen on cases that are filed and that go to trial or don't go to trial is roughly on the order somewhere, but the numbers I've seen are somewhere between 72% and 95%. So I picked 80% on my slide there to just kind of give you a round number on that. Another thing to consider, I say procedurally here, is that litigation takes a great deal of time. There are a lot of people involved in it. There are documents that have to be passed back and forth. The court has to, in a litigation setting, analyze briefs and make decisions and go back and forth. The timing is just terrible. Not uncommon for a case filed today to, even in our jurisdiction in northern Michigan, where things are pretty quick, to take about 2 years to come to trial, if that's the route that one wants to take. During that time, costs continue to rise. They go up again with the depositions and the travel and the interrogatories and the paperwork back and forth and the like, client conferences and so on. That's money that's not in the bank. That's money that may be set aside, or you may have to set it aside to address those continuing costs in a litigation format. And obviously your continued concern about the case that stays open for a long time. So time is a big issue in terms of whether one should have mediation or go to litigation. Another aspect of that is qualitative, and this is kind of underrated, hard to explain sometimes. But for me, I have seen parties stay together as customer and client more times through mediation than they ever have in litigation. Usually litigation is like a sword line drawn in the sand, and in mediation people can come together and discuss their issues, discuss their interests, and trade off between interests and requirements. What do I mean by that? I've seen situations where if there's been damage to a vessel, for example, maybe it fell off the off a forklift, or it fell off the travel lift, and if you were to litigate that, plaintiff marina or plaintiff boat owner rather would say, okay, you owe me X number of dollars, and the marina would say, no, you don't, and go back and forth about what the issues are. And ultimately, if you go to trial, you end up with a situation where the judge tells you what the answer is to your question. And the line that I've given to my litigation clients is, you never know what the answer is until the judge tells you, or the jury in that case, if you've got a jury case. So you're a little bit out of control of what happens, other than presenting your best face to the court. In the qualitative aspect of that is, a marina can say in mediation, I'll tell you what, we can give you three free haul outs, for example, in exchange for the damages that you've done, to try and reach some interest level that the parties have, to try and find a middle ground that's either less expensive for everybody, that's simpler, that keeps the client as a client, and continues the positive feelings back and forth between the two of them. It's very easy in disputes of any kind, whether large or small, to just simply fold one's arms and move forward without without recognizing the needs and the concerns of the other party. And I don't think, on average, that the lawyers help that process very much. But let's talk more about that. One of the key features in confidentiality, and one that's become all the more important lately, is confidentiality. Parties will meet together in mediation and try and decide an outcome of the case, and whatever's said or transacted in the mediation process is confidential. It is not shared with the outside world. Compare that, if you will, to the filing in a lawsuit, where public filings of plaintiff's case complaint and defendant's answer and so on are all public records. And so anyone can stroll in and take a look at those documents to see what's happening in a particular case. And as I say, it's even more important now, where you've got a situation where virtually every court in America is going to online broadcasting of their trials and their periods of time when they're in open court. That means that anyone from anywhere in the world can sit in and see how X Marina is doing against Y defendant, and maybe there's something they learn about their business practices. Maybe they learn something about their competitors and the like. So now, in the era of COVID and online court hearings, confidentiality becomes all the greater concern for those who take the litigation path. And as I say, in mediation, everything is confidential between the parties. One of the other major issues with respect to mediation is that you get to participate in the outcome. You can fashion that resolution that I was talking about earlier, where you might offer some certain amount of small money in a ship store, as opposed to a small claim for damaged canvas or something like that. You have the opportunity to fashion your own resolutions and to come up with conclusions that are qualitative again. But you have control of that, and it's very difficult to do that sort of thing in the litigation process where you're going through court. The last item on this list of why mediation that I have presented is preservation of rights. If mediation fails, again, all things being confidential and the like, you don't have any obstacle to presenting your case through the court system. So you have kind of a double tap if you want to go that way, or if you can't reach a meeting of the minds, why then the court situation is typically available to you. So how does mediation work? In our situation, what we do is we'll get some form or another from one of the parties, and in that process, they will say, we've got a dispute, here are the parties. Being a neutral, the mediator will explore whether or not there is a conflict of interest. For example, in my situation, have I represented a marina in the past as a lawyer, which I would say disqualify me from serving as a neutral mediator. And if none, then we start off with an informational package, and the package is just sort of, this is how we do things. And pretty much what you're seeing in the screen now is the informational package initially. It starts off, it's followed then by an agreement to mediate, and it outlines the terms and conditions under which, in our case, Great Lakes Dispute Resolution will conduct the mediation, and it then requires the signatures of the participants and so on. The agreement to mediate is, again, a contract between Great Lakes Dispute Resolution, in our case, and the parties who are involved. If the parties don't agree to mediate, then again, litigation is still an available resource for you. Typically, it also, of course, involves the hourly rate and costs for the mediator, which are generally split equally between the parties. The agreement requires that the parties agree to act in good faith in mediation. It establishes the confidentiality rules we talked about earlier, and some limits to the confidentiality requirements, one of which is thou shalt not make threats of harm to yourself or others, or threaten criminal activity, that sort of thing. But otherwise, confidentiality is highly structured and very tight. Sometimes cases will come to mediation through a court order, and in that case, the court would likely order the parties to join in mediation and to select their own mediator. And if you can't, then the court will select one for you. And if that were the case, then at least in Michigan, the requirement essentially is if there is no agreement in mediation, you advise the court that the parties met pursuant to the court order to mediate, and there's no agreement, period. So they don't know the context or the involvement. I've had several mediations where a party will come. I'm ordered to be here, and I don't want to be here, and I don't want to mediate. And you report to the court just like any other place where you don't have an agreement. You say the parties have met, and there was no agreement. The agreement to mediate also establishes that the mediator is a neutral, acting neither as a lawyer or an advocate for any party. And again, that's facilitative. I want to talk about that a little bit as we go along. By saying facilitative, I mean the mediator doesn't decide the case. The parties are left to that requirement, to that opportunity, I should say. We also, at this office, send out an informal questionnaire about that time. And what we'll talk about, we'll ask things like, what are the principal interests, the principal issues between the parties? Who are the indispensable parties? If there's an insurance company involved, is the person who has authority in the case available to be present at the mediation, sometimes only by telephone in a face-to-face mediation, and online if a person is if parties are acting in a online mediation. Mediation is something of a fluid process in the sense that you get all manner of opportunities and changes that go along, and so you have to be flexible as a mediator to accommodate all of those needs. The questionnaire would also ask about the preferences of the parties. When do you want to do it? Where do you want to have the mediation? Do you want to meet jointly or separately? Let me explain that for a moment. Sometimes there's so much acrimony between parties in a mediation that sitting in the same room together is a step backwards. That's very rare in my experience, but it does happen. And so you might, in the questionnaire, say, do you think it would be worthwhile to meet separately if you sense that certain acrimony between the parties, or do you want to meet together? And technology, of course, allows us to do this worldwide and bring people in from all over, and to separate them as necessary, and to bring them together as necessary. The questionnaire also invites mediation summaries. So if you want, some cases are involved with legal issues, and lawyers are often involved in mediation frequently, and will be able to say their position in a kind of a brief-like thing, brief-like writing if they want to. we'll follow that up once receiving that information from people. We'll follow that up with a phone call and kind of a technology check if you're going to do an online mediation. We want to be sure that everybody's up and running with the technology. We use the Zoom platform typically, and I find that to be very, very helpful. And then the phone call helps to answer any further questions that might arise because of the answers in the questionnaire. And then we schedule. And we schedule the mediation hearing. So how does the hearing work? The hearing is essentially parties attend the mediation, and again can be separate or together. Mediators typically would prefer that parties are together and that there's not a great deal of trouble between the parties. So that's always good, because face-to-face often works best. You get a sense for people's emotions and the unspoken information that's transmitted just by looking at somebody's face and the reaction to things. But whether jointly or separately, mediator will go over the agreement to mediate, talk about some of the ground rules and the basic housekeeping things. Where are the bathrooms if you're meeting together? How much time do you have? Do you have a conflict in time? How long can we go on? And the like. And remind everybody of the confidentiality of the mediation process. Invite opening statements from each party. Typically the person who brings the case or is the proponent of a particular issue would go first, without interruption, hopefully, and then following that the other party would present an opening statement. And by doing that, you can start to define some of the issues and questions that need to be addressed during the mediation. And sometimes if a party is represented, oftentimes a lawyer will do that. Sometimes the lawyer will defer to the party to make those presentations, those opening statements. Either way seems to work pretty well. Best mediation, and this has happened twice to me, is where after the opening statements, the parties start talking to each other. And most problems, it seems to me, have arisen out of a lack of communication. And so when parties start talking to each other, very often the mediator will just sit back. And what they've done at this point is open a door that does not happen in court, that does happen in mediation. And the best mediations, as I say, is when the mediator does the very least and the parties do the very most. And they take over to reach a conversation and reach a resolution on their own. That's happened to me twice in, 20 years, but it can happen. In private session, which is sometimes called caucuses, the mediator will separate the parties. This can be done digitally online, or it can be done in person in separate rooms where you have those facilities available. And what the mediator does at that point is listen to the underlying story, and very often there's a story that you haven't heard before, or an angle, or a position, or a legal argument, or whatever that has not come out and not been disclosed and not been discussed with the other party. And start acting as a settlement coach. What is this worth to you? How much are you willing to pay? How much are you willing to receive? What is the best resolution for this case? How would you, I heard this need from the other party. How would you resolve that need and still get what you need? Sometimes the mediation, I'll say often, the mediator is involved in doing a reality check. What do you think this offer would sound like to the other side? If you offer $10 on a $50,000 claim, and you know that you're willing to settle for $25,000, why would you make a $1 offer? I mean, what's the point that you want to make with that? How will that be seen? And so, in that sort of way, become a settlement coach. And oftentimes you get down to reminding what's at risk in a trial or in a case if it goes to trial. What are the costs? What are the benefits? Will you maintain the client relationship or the customer relationship that you have with this individual, or are you throwing that out? Does it matter? It may not matter. But the decisions in that respect remain those of the party. And in that private or private session or caucus, as they say, those conversations are confidential as well within that caucus, within that private meeting. And purpose of that is so that people can talk freely with the mediator, and the mediator can get a sense of where people are. And there have been times, probably 15 times or so over the years, where one party there'll be overlapping offer, and then try to find a way where the parties can express that to each other in a way that actually resolves the case. And that's been very helpful as well. But the decisions always remain those of the parties. So whatever's said in caucus or private sessions is not related to the other side unless and until the party making the offer or making the statement authorizes the mediator to make those statements to the other side. So they'll be very careful about that. And in that coaching, that confidentiality is paramount. We've also done quite a number of online mediations of late, and there's good and bad to that. The online mediations are kind of dictated by the COVID situation, but they've also helped a lot in cost reduction. But let's talk about those. The pros and cons, if you will, of online mediation. They're cost effective to have an online mediation. There's no travel for anybody. If you have witnesses, if you have, and typically people don't bring witnesses, but the parties don't have to travel to a central location or one side or the other location. You don't need to bring in a insurance adjuster in from wherever to the mediation site. It's easy to share documents in an online setting. It's easy to do shuttle diplomacy, the moving from one room to another, as you would do physically in a face-to-face meeting, where you had those private sessions that I was talking about. So it's very simple to do that online. It requires less time to arrange the logistics of the mediation. You don't have to. Sometimes a motel room is hired, halfway between the parties' locations and that sort of thing, for a face-to-face meeting. So an online mediation changes all that. It is environmentally friendly. You don't have the gas and the carbon footprint of travel with an online mediation that you do with a face-to-face mediation, and it's very effective. Cons: it's not as personable. Right now, I think you're seeing my slide, but not my face. So in most cases, we can pull all of the things together. The technology today doesn't allow that to happen, but we would share documents and see face to face mostly. But it's not as personable, and I don't think anyone would argue with that. Face to face might be a little more effective for mediation. We are, after all, social creatures, and maybe having to spend more time and travel farther makes us want to resolve the case more. That I don't know. And confidentiality may be a little trickier to just be sure everybody understands what everyone else is thinking. But I haven't seen any real confidentiality issues in online mediations. Again, my information carrying here. Fees and costs are divided typically, mediators' fees and costs are divided typically between the parties. Rates are about the same as a lawyer would charge for an hour of time, would be the same as the mediator, but then it's divided between 2 or 3 parties, however many are involved in the mediation. And that's about all I have. I would say that these slides that we put together are available to anybody who would like them, and I'm sure that Docs Expo will help make that all happen as needed, and we're happy to answer any questions that might go on that you might have today. Sorry, I missed that last.
Oh, we were just announcing that we can relay any questions.
Fair enough.
I don't think we've got any questions. All right.
All right.
Thank you.
Well, thank you all very much. Appreciate it. Have a great exposition.
Thank you, Lee.
All right. See ya.